everyone. My name is Ritesh and today we'll discuss the current affairs topic. And today's topic is inheritance of daughter, right? So, Supreme Court recently announced something related to inheritance of daughter. We'll discuss this whole thing in very detail in this topic, right? So first, let's take a overview of this whole topic, what we will discuss in this video as well. So first, we'll discuss why this particular thing was in news. Then we'll discuss the daughter's inheritance in this. Then we'll discuss the ancient text and judicial decisions related to the whole topic. Then the property after woman's death. What will happen to the property after the woman's death? We'll discuss. Then the land rights and women in India. And then lastly, we'll discuss the Hindu Succession Act, right? So let us start with this topic first. Why this was in news? So recently, Supreme Court has ruled that daughters will have equal rights to their father's property even prior to the enactment of Hindu Succession Act of 1956. So Supreme Court made a clear observation and they said that the daughters will get equal rights to their father's property even prior to the enactment of Hindu Succession Act 1956. Now, why this thing came in news, right? So, the case involved a dispute over the property of a person who died in 1949, leaving behind a daughter who also died issueless in 1967. So, this was a case actually that comes before the court. In this case, there's a dispute over the property of a person who actually died in 1949, leaving behind a daughter. That person has a daughter who also died isolation in 1967. So again, the property, now what will happen to that property? The Supreme Court said that the court said that the daughters will have equal rights of their father's property even prior to the enactment of Hindu Succession Act. So in this, if we talk about this case specifically, the trial court held that since the person had died prior to the enforcement of Hindu Succession Act 1956, therefore the petitioner and the other sisters were not the heirs, as on the date of his death was not entitled to partition of share in the suit properties, right? So the trial court said, declared the decisions that the petitioner and her other sisters were not the heirs because that person had died prior to the enforcement of the Act, Hindu Succession Act 1956. Right, that is why the trial court had said that because that person had died in 1949 itself and the Hindu Succession Act came in 1956, that is why the daughters and the were not the legal heirs of the father property. Right. Now later the High Court too dismissed the appeal against the trial court. The petitioners actually appealed over the order of the trial court, but the High Court too dismissed the appeal against the trial court, right? So now let's talk about the daughter's inheritance, right? So in this, it ruled that the property of a man who had died without executing a will and is survived only by a daughter will devolve upon the daughter. It says that if a property if a man had died and if that man possessed some kind of properties and if that person died without executing a will and that person is survived only by a daughter, so the daughter will get the property of that of her father, right? So the property will devolve upon the daughter itself, right? Then in 2020, Supreme Court already expanded the Hindu women's right to be the co-partner, joint legal heir and inherit ancestral property on terms equal to male heirs. Now again, if we talk about daughter inheritance, we have this particular kind of thing that if a person died without executing a will and is survived only by a daughter, the daughter will get the properties and the properties will be devolve upon the daughter. And in 2020 itself, Supreme Court expanded the ambit of again Hindu women's right, because they said that women are the legal heir, joint legal heir as well, and they can inherit ancestral property on terms equal to male heirs. So in terms of daughter inheritance, they have equal rights as per they have equal rights with respect to men, right? Now, in this case, again, in this case, Supreme Court referred to many ancient texts, even judicial pronouncement as well. They have referred. So we'll discuss this thing too also. So Supreme Court looked into Vyavastha Chandrika. So this is actually a digest of Hindu law by Sham Charan Sarkar. So you don't have to remember this name, right? So just remember this. Because Supreme Court looked into this particular thing, it is a digest of Hindu law, right? Which quoted it. This digest actually quoted Vrihaspati as saying the wife is pronounced successor to the wealth of her husband. In her default, the daughter. As a son, so does the daughter of a man proceed from his several limbs. Now, this digest called Vyavastha Chandrika, right? So it says that women are also the equal higher as men, right? It specifically quoted that the wife is pronounced successor to the wealth of her husband, and in her default, the daughter. As a son, again, this digest is saying that because son and daughters, they both have the equal rights in the property of their fathers, right? So this is the first thing that Supreme Court referred as a right. Then second one is the Supreme Court noted that the book quoted Manu as saying the son of a man is even as himself and the daughter is equal to the son. How then can any other inherit his property, notwithstanding the survival of her who is as it were himself, right? So again, Supreme Court noted that the book even quoted Manu also saying that the same thing, that the son of a man is even as himself and the daughter is equal to the son. So again, the same thing happened, that the son and the daughter will get the equal rights as per them, right? Then if a property of a male Hindu dying intestate is a self-acquired property or obtained in partition of a co-partitionary or a family property, the same would devolve by inheritance and not by survivorship, and a daughter of such a male Hindu would be entitled to inherit such property in preference to other collaterals. Now this thing is also again saying that if a male Hindu, right, if they die intestate, right, and they have self-acquired property or obtained property in partition of a co-partitionary or a family property, right, then that property would devolve by inheritance and not by survivorship, right? So in inheritance it will come back to the daughter as well too. If that person has a daughter already, then the main point here is that the property would devolve by inheritance and not by survivorship. Just remember this particular thing. So in inheritance wala case, we have daughters and they can get equal property rights, right? Then what will happen after the property after the woman's death, right? So the court said that if a female Hindu dies intestate without leaving any issue, now if a female Hindu die intestate, it means she does not execute the will, then the property inherited by her from her father or mother would go to their heirs of her father, right? So there's two classification in this point. First, just imagine if a female Hindu dies intestate without leaving an issue. Now that female Hindu can acquire property from two sides. One is from the mother side, right, from her mother or father side, and second is from her husband or father-in-law side. So in case of father or mothers, the property obtained from the father's or mother's side, the property would then that property would go to their heirs of her father, whereas the property inherited from her husband or father-in-law side would go to the heirs of their husband, right? So it is very simple. Two classification hai. First one is the property that comes from the father or mother side, and second one is the property that comes from husband or father-in-law side, right? And how they will devolve upon these kind of properties, right? Just remember this thing. Next one is, In case a female Hindu dies leaving behind her husband or any issue, then section 51A of the Hindu Succession Act will come into operation, and the properties left behind, including the properties which she inherited from her parents, would devolve simultaneously upon her husband and her issues, right? So these pointers are self-explanatory, right? So this is very simple, that how if a woman died without executing the will, then what will happen to the property, right? And what kind of property she can acquire during her lifetime, and how that acquired property will get inherited by some kind of people, right? This is all about the property, and you will not expect question from this side and as well, because if we consider this whole topic, inheritance of daughter, the question will devolve upon that what is the Hindu Succession Act and the cases related to that in the early 2020 or 2021 itself. That's it. Otherwise, these all things are just for your basic understanding and the comprehension wala part, right? Now let's discuss the land rights and women in India. Right. So land rights and women in India. A 2020 University of Manchester working paper, they have found that barely 16% of women in rural land owning households own land, right? So about barely 16% of women in rural households, they own land, right? And this is very less. So that is why we are saying that even we give them land rights, but still the practical application is very less, right? By the facts and data itself, we can deduce that. Then, in deep patriarchal, most and rural agrarian settings, property which is seen as primary source of wealth is largely inclined to be passed on to the male heirs. Obviously, in the rural, we have patriarchal society, and then in that kind of society, we have seen that land is actually a primary source of wealth, right? Property is a primary source of wealth, and this particular thing is primarily inclined to the male heirs, right? This is the history which we are talking about. Then inheritance laws. Then the inheritance laws for agricultural land remain a minefield with conflicting central personal laws and state laws, right? So again, in inheritance laws, there are so many contradictory opinions of personal laws, and then state laws come into place, right? So there are so many conflicting positions over there. For example, we can say that Haryana twice tried to take away the progressive rights given to a woman through Hindu Succession Act 1956, while in UP since 2016, married daughters are not considered primary heirs, right? So again, these state laws are in conflicting position with Hindu Succession Act, right? Then there are personal laws that comes with the kind of inheritance that they own, right? So again, these kind of things happen. I've given an example of Haryana and UP itself, that how these kind of rights are happening over there, right? Then there's a lot of ground level resistance to registering land for women in several North Indian states. Thus, women's empowerment and property rights remain an unfinished project. Yes, we have given so much rights to women, but in practical sense, they won't get such benefit over there, right? Even some states, there's something that is going on in society, right, which stop you to doing these kind of things, right? For example, Haryana does the same thing. In UP, for example, from 2016, married daughters are not considered as a primary heir. So what kind of differentiation you are making there, right? So there must be a common law for that, for the whole country. UP takes out some other kind of laws. Then Haryana has some other kind of. So again, I'm talking about the contradictory positions of laws in various states to the central laws, even to the Succession Act itself, right? If we compare these state laws and the Hindu Succession Act, we have contradictory opinion, right? So this is. Then let's talk about the Hindu Succession Act and then the Hindu Succession Amendment Act. So in Hindu Succession Act, the Mitakshara school of Hindu law, codified as Hindu Succession Act 1956, it governs succession and inheritance of property, but only recognized male as legal heirs, right? So Mitakshara school only recognized male as legal heirs. It applied to everyone who is not a Muslim, Christian, Parsi or Jew by religion. So Hindu Succession Act applies to everyone who is not a Muslim, Christian, Parsi or Jew by religion. Then it means Buddhist, Sikh, Jain and followers of Arya Samaj, Brahma Samaj are also considered Hindu for this law, right? So Hindu Succession Act covers Hindus. So in the broad aspect, we can say that Hindu covers Buddhist, Sikh, Jain, followers of Arya Samaj and Brahmo Samaj, right? Who are not available in this? So Muslim, Christian, Parsi or Jew by religion are not being covered under this act. Now, traditionally, only male descendants of a common ancestor along with their mothers, wives and unmarried daughters are considered a joint family. And the legal heirs hold the family together. The legal heirs hold the family property jointly, right? Because again, the legal heirs get the property of that of the person itself, right? So they hold the family property jointly, right? Then let's talk about the amendment of this act, right, which happened in 2005. So Hindu Succession Amendment Act 2005. Now the act was amended in September 2005, and as per that, women were recognized as co-partners for property partitions arising from 2005. Now Hindu Succession Act does not talk about female as a legal heir. It only talks about the male as a legal heir. But after this 2005 amendment, women were recognized as co-partners for property partitions arising from 2005. Now, Section 6 of the Act was amended to make a daughter of a co-partner also a co-partner by birth in her own right in the same manner as the son. See, son get the equal right by birth, right? So, through the amendment of Section 6, this act provides daughter the same right as they are giving to sons, right? They will be a co-partner by birth itself, same as son. How they get this act? Get this thing by amending the act, Section 6 of the Hindu Succession Act. So you have to remember Section 6 because it talks about the co-partnership of female. Right? So Section 6 was amended in 2005, then this was introduced. Then it also gave the daughter the same rights and liabilities in the co-partnership property as she would have had if she had become a son. Again, the 2005 amendment talks about the women's rights in the Hindu Succession Act, and this they get equal rights as son. Now the law applies to ancestral property and to intestate succession in personal property, right? So this application is for ancestral property and to intestate succession in personal property. So that's all about Hindu Succession Amendment Act. Why I have mentioned? Because that's how women get rights under this act. Because earlier only male were the legal heirs as per the Mitakshara school of law and the Hindu Succession Act. But after the amendment, women get the equal rights. In which section? Section 6 of the Act. Now, the last point in this Act itself, school of Hindu laws, which I have discussed, the Mitakshara, that's where from Hindu Succession Act came, right? So let's discuss Mitakshara Law School and Dayabhaga Law School, just difference, right? So the term Mitakshara is derived from the name of a commentary written by Vijneshwara of the Yajnavalkya Smriti, right? And the term Dayabhaga is derived from a similarly named text written by Jimutvahana, right? So this is not relevant, first point. Second, it is observed in all parts of India and subdivided into Banaras, Mithila, Maharashtra and Dravida schools. And Dayabhaga school is observed in Bengal and Assam. Now this is important for you to notice that Mitakshara law school covers the Banaras, Mithila, Maharashtra and Dravida schools, and they are all there in all parts of India, but the Abhaga Law School is observed only in Bengal and Assam. Now, as per the Mitakshara Law School, a son by birth acquires an interest in the ancestral property of the joint family, right? But as per the Dayabhaga school, a son has no automatic ownership right by birth, but acquires it on the death of his father. Now, let's make a clear distinction of these two things, right? So, as per Mitakshara Law School, if a son is born, that son acquires an interest in the ancestral property of the joint family. But in Dayabhaga school, by birth you are not having any benefit, but after the death of his father, the son will get the interest in the son will get the right in the ancestral property, right? Then, as per Mitakshara Law School, all the members enjoy co-partitionary rights during the father's lifetime, but in Dayabhaga Law School, sons do not enjoy co-partitionary rights when the father is alive. They'll get the right when the father, after the death of his father, then they'll get that right. Then, as per Mitakshara Law School, a co-partner's share is not defined and cannot be disposed of. But as per Dayabhaga Law School, the share of each co-partner is defined and can be disposed of. Now, last is, as per Mitakshara Law School, a wife cannot demand partition but has the right to share in any partition between her husband and her sons. But in Dayabhaga Law School, the same right does not exist for the woman because the sons cannot demand partition as the father is the absolute owner, right? So, this was all about the Mitakshara and Dayabhaga Law School. Just have a basic understanding of these law schools and where it applied, because the application is important. Remember this, that Mitakshara Law School applies in India everywhere, but that particular school has 4 sub-schools, which is Banaras, Mithila, Maharashtra and Dravida, and the Dayabhaga Law School, it is being applied in, observed in Bengal and Assam, right? So, this was all about the inheritance of daughter, right? So, again, this was all about the inheritance of daughter, why this was in news, why this case comes from, and I have also discussed the school of law. So, just go through this. So, thank you so much for this topic.